Talking with my client and an additional consideration, my client is going to waive his right to preliminary exam and have this matter bound over to the circuit court for additional proceedings.
That is my understanding as well.
Sir, you need to face me. You're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is.
In court, every choice matters, one wrong move, and your freedom hangs by a thread. Defendants waive rights, plead guilty, and face bond violations, all under the unforgiving eye of the judge. This is where mistakes get exposed, and mercy is rare.
Bound over to circuit court on all 5 counts. Counsel, you acknowledge receipt of the information, waive its reading?
Yes, Your Honor.
And how does your client plead?
Not guilty, Your Honor.
All right. Defendant having waived formal reading, pleading not guilty, court will enter a not guilty plea as to all 5 counts. Pretrial in this matter will be set for
January 7th at 1:30 before Judge Conlon.
January 7th, 2026, 1:30 before Judge Conlon. Bond in this matter will continue.
Thank you, Your Honor. Have a good day, you and your staff. Happy holidays.
And to you, sir.
Thank you, Your Honor.
Thank you.
Can I approach, Your Honor?
Yes.
Yes, it is ready.
Court does call the case, People versus Jonathan Hughes.
People.
Good afternoon, Your Honor. J. Grant Miller, P58658, on behalf of Jonathan Hughes.
Jonathan Hughes.
All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading. Well, it's not checked. Is he pleading guilty?
He's pleading guilty, Your Honor.
He's pleading guilty to the charge of use of a controlled substance, that being cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the rule.
Yes, Your Honor.
Mr. Emmons, that is my understanding. I think Mr. Emmons will verify the plea now.
Thank you, Jonathan Emmons, on behalf of the people. We have this case. You'll have a plea to add account 2.
I think I already said this if you've been in the room.
Do I confirm that?
I have it.
Raise your right hand. Do you solemnly swear and affirm the testimony about to give the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name, please.
Jonathan Hughes. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of use of a controlled substance. Yes, sir. Cocaine. Yes, sir. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? Yes, sir. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. Yes, sir. All right. Still wish to plead guilty? Yes, sir. And to that charge, how do you plead? Guilty. Now you understand by pleading guilty, you'll not have a trial of any kind? Yes, sir. You signed an advice of rights form, is that correct? Yes, sir. Any question regarding any of those rights? No, sir. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form? Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? Yes, sir. Were you on probation or parole at the time of this offense? No, sir. Has anybody promised you anything other than what's been stated here today to get you to plead? No, sir. Has anybody threatened you or coerced you? No, sir. You're doing this voluntarily? Yes, sir. Of your own free will? Yes, sir. And because you believe that you're guilty of this offense? Yes, sir. January 19, 2025, at the location of Harriet Street, Ypsilanti City, Washtenaw County, State of Michigan. Did you have cocaine in your possession? Yes, sir. Had you used it? Yes, sir. Did you know what you were using was cocaine? Yes, sir. Sir, if I accept your plea and you commit misconduct between the time I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
I'm satisfied with that.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
January 7th at 10 a.m. before Judge Barr.
January 7th, 2026, 10 a.m. before Judge Barr.
Yes, Your Honor. If I could address the bond condition, Your Honor.
Sure.
He actually has a release to treatment and he's being held on those cases. We were just requesting that this court would consider releasing him to treatment. I believe there's a bed available for him, and this was the last thing keeping him out of treatment.
Any response from the people? Prepare an order. As usual, I'll sign it.
Thank you, Your Honor.
Thank you, Your Honor.
At this point, your bond will continue. Once I get that order, I'll sign off.
All right, thank you, sir.
Thank you. Court does call the case, People versus Jesse Lee Rogers.
Senator Jonathan Evans on behalf of the people.
Good afternoon, Your Honor. Alex Warren Green on behalf of Ms. Rogers. Ms. Rogers, could you please state your name for the court?
Jesse Rogers.
Thank you.
Your Honor, thank you. Good afternoon. Today, the time set for the preliminary exam in this matter. I had an opportunity over the weekend to review the reports. I spoke to Mr. Warren Green. There is a handful of documentations that are alluded to within the report that neither party simply has. I went through it and I'm not sure, it doesn't look like it ever happened. I reached out to the records department of the sheriff's office as well as the OIC, who now is at a different police department. And they're looking into it, but I've not received those documents as of this time. I am unable to adequately perform this exam. And so I'm going to respectfully ask for.
Why weren't, I don't understand.
And Your Honor, our position is I'm asking for a dismissal. When we set this examination, I set it with the understanding that we had everything the people had. And I believe that to be true today. I'm asking for a dismissal because I don't think it's the case that discovery is incomplete. I think the people are simply missing evidence they need to move forward with this case.
Well, which is it? I mean, there are things referred to, what I got out of that was there are things referred to in the report. Do we know whether they exist or don't exist? And if they exist, why haven't they been given to the defense prior to now and certainly prior to the time that this examination was set?
So the report refers to a couple of different items, i.e. a spreadsheet from the University of Michigan Credit Union, as well as a phone call. And it says that the phone call was uploaded to evidence.com. I go to evidence.com, I don't have it. It's just not there. The spreadsheet, there's something that might be the spreadsheet, but I'm not sure if it is the spreadsheet. So there's things that are in the report that I don't feel comfortable. I bet the phone call I just don't have. The spreadsheet, maybe it's there. I'm not 100% sure that that's a spreadsheet. It doesn't look like a spreadsheet, but
I don't know what that means. Is it a spreadsheet or isn't it? I mean, if it refers to a particular document, I think you'd be able to try to figure out what it is.
I think if it was copied and pasted from Excel and then into a Word document, it would have just been a formatting error that I wouldn't necessarily be able to make heads or tails of.
And Your Honor, what the defense is in possession of is what purports to be the complainant's banking app records. Those are contained in what is a spreadsheet, and that was produced. What I think the people are missing is Verizon records that are mentioned in the report, but were not produced, are not in the people or the prosecutor's office possession, and certainly haven't been turned over to the defense. I believe we have everything they have.
Why are those records as a proffer necessary for the exam?
The way that I believe that I can prove the case is to show the connection between the defendant and her use of an IP address that comes back to her phone number. And I don't have any of those documentation.
Then how did it get charged?
It's a good question, Your Honor.
Oh, yes, it's a good question. And I don't know whether she's guilty, not guilty. She's presumed to be at this point in time, but she's been going through this process. And you get to the date of a preliminary examination, her first step, and you're telling me you can't show the case and that there's something out there that you don't have, never had, that would link her to this case. So why is she? Going to grant the defendant's motion. This case is dismissed. It is without prejudice. So, ma'am, you need to understand that they can bring the case back, but I'm going to give you fair warning. You bring it back, you better be ready to go. You better have everything that would tie this defendant to this case, or there are really going to be problems. Thank you.
Thanks, Your Honor.
Thank you, Your Honor.
Courthouse case, People versus Michael Donner.
Hey, I was on behalf of people, Your Honor.
Good afternoon, Your Honor. James Fifelski on behalf of Michael Donner, who's to my right. State your name.
Michael Donner.
Your Honor, we're ready to proceed with exam on this case.
Your Honor, at this time, if people are unable to see this to counts 1 and 2, to ask for count 3 to be remanded down to the district court.
We move for dismissal of counts 1 and 2. Now, I would like to address bond on count
If
3.
it's going to be that same argument, we're going to have a problem.
Well, it's slightly, Your Honor, because of these
Counts
circumstances.
1 and 2 are dismissed. I'll continue with not guilty plea. What is count 3? What do you have as count 3?
Domestic violence, first offense.
That's what I've got too, Judge.
You look at this. See what I'm saying?
Yeah, I see that.
I know. Oh,
This is wrong.
that's wrong.
This is wrong.
Those are 1 and 2, and it's a DV. They never included count 2. Well, no. Yeah, they never included the real count 2. And so count 3, sorry, got it. Count 2 was interference with electronic communication. Actually, there it is. It's right there, but I got it entered there wrong. Can you check, did this come directly from JS? Can you check what JS has?
This is a separate document by the clerk's
Right.
office. Not from
Right,
JS.
so check to make sure JS has a 3. Because otherwise they're gonna have to correct something. I'll continue to defendant's not guilty plea as to count 3. Set this for pretrial on before Judge Freshour.
January 15th.
January 15th, 2026, at what time? 10:30, before Judge Freshour. As to bond,
Your Honor, is that at 1484 or 3?
it's a 1484 case.
Thank you, Your Honor. Your Honor, as to bond, I would ask, given the circumstances that 2 felonies were dismissed, and this is a unique situation in terms of, I think, much more hardship to my client's family, including his wife, than to him himself. His mother-in-law has reached out to me to beg me to try to get him out of jail to take care of this family. His wife is a stay-at-home mom. He's the sole breadwinner. Even if she has to get a job for the next 3 months. She's got to pay extra daycare expenses to get these kids daycare because otherwise she would be taking care of them while my client's out working. I just spoke to his mother who said he could reside with her in Chelsea. I've got an address. I'd ask the court to tether him to the address, allow him to work. The court can assess his whereabouts and ensure he doesn't violate anything. He has never failed to appear at court. He turned himself in on this original warrant, I believe. And I understand we had a bond violation before, and I would just.
Well, two of them. It's not just one.
I
He just doesn't
understand.
think he has to abide by the court's orders. That's the problem.
Well, I don't think it's that. I think that he had poor judgment in terms of how he went about what he had to do just to get some things and see his kids. And I understand it is a violation. But he has now spent the last 12, 13 days in custody. That certainly sends a strong message. And just, again, we're talking about Christmas time. And he's got 5 young kids who rely on him to take
I
care
don't
of
know
their
how many
financial
women are going
needs.
to die over the holidays from somebody that's a domestic abuser either, Mr. Fifowski. So I don't think we ought to be using Christmas time as some type of mitigating factor.
Well, I would just ask, given the fact that it is but given the fact that, yes, the young children look at this as a special time, and I get it. My client is the one who made whatever decisions he has, but he's certainly willing to do whatever the court requires of him to ensure his appearance and safety in the community.
Response from the people.
Your Honor, at this time I would object. It was 2 clear bond violations. He was given clear instructions at arraignment not to contact the victim. It was set for third-party contact about child care. He broke that, and then he was at the residence. And I mean, it can't be any more clear. He's seen leaving the residence, he was told not to do it. So I have concerns he can't follow court orders because he broke 2 of the conditions he was given at arraignment almost immediately after arraignment. The first being the calls, and then after he gets out of jail, bonds out, he goes right to the house. So at this time, I'm going to object because I don't think he can follow court orders.
His bond at this point is sitting at revoked. I will grant him a bond on this case. I'll grant him a $50,000 10% bond. Same conditions apply. I'll just say this, if you don't listen to him and you get before Judge Freshour, you're going to have heck to pay. You think this was rough. I would indicate that there will be a GPS tether prior to release. That GPS tether, I am not going to give a release to work. I'm going to let Judge Freshour make that decision as to how far out he can go and what he can do, because he just can't seem to follow anybody's instructions. So I think it's probably better that it come from her. So it's going to be a GPS home confinement and with no release for anything at this point until he receives permission of the court to do so.
Thank you, Your Honor.
Thank you.
Court does call the case People versus Dylan Chapman.
Your Honor, Alexis Pluma, Assistant Public Defender, appearing with and on behalf of Mr. Chapman. Mr. Chapman, could you state your name for the record?
Dylan Chapman.
Thank you.
And Your Honor, today is the date and time set for preliminary examination. I understand there is a bond violation. However, also at this time, people are unable to proceed as to counts 1, 2, 3, 4, and 5, and would ask for count 6 and 7 to be remanded down to district court.
So you're unable to proceed on 1 through 5
Correct.
and would like 6 and 7 down. Got it.
Correct.
Counsel, you're moving to dismiss counts 1 through 5.
Yes, Your Honor.
Continue to defendants not guilty plea as to count 6 and 7. I set this matter for pretrial.
January 29th at 10:30 for Judge Factual.
That date might change. There's an in custody. We'll see, but you got the 29th right now, correct?
Yeah.
Got it. What time? 9?
10:30.
10:30. Before Judge Fresh Hour. As to the bond violation.
Yes, Your Honor, I have had an opportunity to discuss the violation with my client. He has provided me with an explanation that he feels comfortable with me sharing with the court. This was reported as a hit and run accident. Mr. Chapman states that the complainant in this case was using his car, which she had reached out to his mother and asked if she could borrow because hers was either broken or not able to drive in the snow. He states his mother gave her the keys to the car and allowed her to use it. And then Mr. Chapman states that at some point that night, his mother called him and let him know that the complainant had been involved in a hit and run accident with his car. He tells me that he did go to the scene of the accident to try to check on his vehicle, and that at that point, the complainant was not actually present. It's unclear to me in the report at what point in time the police made contact with the complainant because it was a hit and run accident. I'm not sure if contact was made at the scene or later on, and there's not a whole lot of detail there. So Mr. Chapman is asking that the court consider keeping his personal recognizance bond in place, given that explanation, and potentially setting for a pretrial and bond violation combination in front of Judge Fresh Hour so that if there is more detail that needs to be provided, Judge Fresh Hour could consider that.
Your Honor, at this point, I have concerns given the nature of that bond violation with his wallet, his other property being in the car. He's not there. I would have concerns about contact with the victim, being there with her, especially given the nature of the charges. At this point, I would ask that he be remanded on the bond violation.
Your Honor, again, the only thing I will add is that Mr. Chapman explained to me that his wallet and other items were in the car when his mother provided the car to the complainant. So again, he's just asking that the court consider. Yes, Your Honor.
That his wallet, ID, and all of his everything is still in his car.
Yes, Your Honor.
And she.
My understanding is that the car was supposed to be returned to his mother soon thereafter, and that Mr. Chapman said it was okay to leave his wallet in that case the complainant needed to use his debit or credit cards.
So how close was he when this vehicle crashed? Because they have him one driveway over.
Yes, so Your Honor, he states he did go to the scene of the accident after his mother told him that there was a hit and run crash to check on his vehicle. However, it's unclear to me in the report, and based on what Mr. Chapman is telling me, at that point in time, the accident had already happened and the complainant was no longer there, and he was just going to check on his car. So again, I'm not sure because it's unclear in the
How
report
do I know
whether,
the complainant's not there if she had the car? From this defendant?
so the complainant's not at the scene of the accident.
Yeah.
Right. We don't know. And I'm saying that it's unclear to me when contact was made with the complainant, at what point in time.
I hear you, but none of that makes any sense to me because it almost seems like he's with the complainant. The vehicle crashes, she leaves, and he's still there. That's why the only thing that makes sense as to why his wallet, ID, all of that stuff is still there because he was in that vehicle when it crashed.
And that is not the explanation that he is providing.
I get that.
Yeah.
But none of the other part makes sense. I'm not. Anything else?
No, Your Honor.
I think when I look at everything that the defendant was having contact with the victim in violation of the bond conditions in this case, and based upon what was said, at this time, I will move his pretrial date up to January 15th, 2026. That's still at 10:30.
Yeah.
January 15th, 10:30. But at this time, the court's going to believe that there's enough evidence and to indicate that there's been a bond violation. I'm revoking the defendant's bond. The defendant is remanded. Court calls case People versus Carlos Hicks.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Ridgefield on behalf of Carlos Hicks on case ending in 0150.
And Sherilyn Foster Tucker on behalf of Carlos Hicks in the other case.
All right. What? Oh, this. Who's on the? Is there a prosecutor on this case? Okay. And where's your client?
I can't say for sure, but I wasn't able to make contact with him. However, my impression is that there are not witnesses here present on the larceny case. If that is the case, I would still ask to dismiss.
Your Honor, I would just echo what the public defender just indicated.
Well, but have you had any contact with him?
No, Your Honor, and I did just receive this case late yesterday.
Yes.
Late yesterday, but I have no explanation for the app.
Bench warrant will issue for the defendant's failure to appear on both cases. Bond in each case will be set as $25,000 cash surety. Those warrants will issue immediately.
The courtroom doesn't forget. Every plea, every violation leaves a mark. Follow orders, understand your rights, and remember, justice moves fast and second chances are fragile.